All right, so thank you everyone for joining us for today's webinar, which is looking at the Brisbane Youth Service and Beven case. My name's Carly, I'm from Community Legal Centres Queensland, and I'd like to welcome everyone here today. So before we get into the meaty part of today's webinar, I'd like to acknowledge the traditional owners of the land on which we're holding this webinar. In Brisbane, they are the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the very important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by CLC people and others across Queensland and Australia, I'd like to pay my respects to the traditional owners of the land throughout the country, and also extend a warm welcome to any First Australians listening in today. So today's webinar is a slightly different format to usual. We're actually going to be focusing on the case of Brisbane Youth Service Inc. and Beven, which was a 2017 decision of the Court of Appeal in Queensland. So, you know, as our focus for CLCs is generally on our clients, we do sometimes need to look outside of that and ensure that we're making our workplaces safe for our clients and for our staff as well, and taking into account any risk management issues and making sure they're not forgotten. So today we have Helen Whitehurst from Ashurst joining us to discuss the implications of the Brisbane Youth Service and Beven decisions, and there are two, for work health and safety, risk management and employer duty of care in community legal centres. So today's webinar will be recorded. Hopefully it works today. We had some issues earlier in the week. We'll hold questions to the end of the session, but feel free to type anything into the question box as you think of it, and we'll deal with those ones once the substantive part of the presentation is done. I sent out the PowerPoints for that Helen has provided yesterday afternoon, and they've also been uploaded to the handout section of the GoToWebinar control panel if you'd like to download those. We're also going to run a couple of polls first thing today, so you'll see those pop up on the screen, so please pop your answer in there, and that will give us a really good idea of who's viewing today's webinar and your knowledge of the case that will be discussed. So I think that's everything I need to cover for the minute. I will also mention there may be some, if you have any concerns about the content of today's webinar, because there are some, you know, perhaps difficult issues being discussed in relation to this case. So please have a look at our website, communitylegalqld.au/keepsafe, and that links to some helpful resources that you might like to have a look at. So I might launch the first poll and introduce Helen Whitehead from Ashurst, who's presenting today's session. Thanks, Helen. I'll pass it over to you now.
Thank you, Carly, and thank you everybody for joining us this morning. So just while everyone's answering the questions on those polls, I'll just go through the learning objectives for the presentation. I'm not sure whether everyone can see my screen at the moment, but essentially the presentation is to provide a basic knowledge or a refresher for those who are already familiar with an employer duty when it comes to staff safety, and also to consider what steps can be taken in a community legal services environment to reduce the risk of employees sustaining an injury, whether that's physical or psychological, through client interactions. So I'll start just by running through the factual scenario that led to Ms. Beven's injury. Brisbane Youth Service, or BYS as I'll refer to them, describes itself as a provider of support services to homeless and at-risk young parents and their children. The services are intended by BYS to move such parents from a position of vulnerability and isolation to community and personal strength. And evidence was led that the service tends to attract complex clients, including victims of sexual abuse and drug addiction. So Ms. Beven was employed by BYS as a family support worker. She had a Bachelor of Behavioural Science with a major in psychology, and also a Bachelor of Arts with a major in psychology and minors in laws and sociology. She described her areas of specialty as conflict resolution, youth homelessness and issues affecting homelessness, depression, suicide prevention, sexual abuse, and a strength-based social justice framework. She came to be employed by BYS in around 2007, and at this time she had approximately 8 years previous experience as a youth worker and a behavioural therapist. Ms. Beven also had her own history of sexual and violent abuse as a child at the hands of some family members and other men. And while pursuing her second degree, she had to complete a mandatory assignment on sexual abuse. And her past experiences led her to decompensate at this time. And she spent some time as an inpatient in a mental health unit. She underwent counselling for some time, and she also required antidepressant medication. But by the time she came to work with BYS, she was doing well and she was happy in her marriage. Her history of abuse wasn't revealed to BYS at any time, and there's no suggestion that that kind of information should have been disclosed to her employer. So the incident that led to the litigation occurred on the 13th of April 2011, when Ms. Beven was sexually assaulted by a client who was referred to in the decision as T. So T was herself the subject of a child protection order when she came to use the services of BYS. Her background isn't detailed in the decision, but she came to the attention of the authorities in August 2008, and at this time she was still a minor. She was a methamphetamine user, and she was also pregnant with her second child, with already an infant daughter in her care. So in August 2008, she was found by child safety officers unconscious in her home. She was affected by drugs, and her infant daughter was close by in a pram with a blanket over her head. So her daughter was placed in care, and the department prepared a report which said that T had a history of violence, self-harm, suicide attempts, instability, and sexualized behaviours. So ultimately, T's daughter was returned to her care, and the department developed various goals for T. And it seems that at this stage, T self-referred to BYS for what was referred to in the decision as general counselling. So there's a timeline here that sets out T's interactions with BYS prior to her coming into contact with Ms. Beven. The first employee from BYS to meet T was Susie Turner on the 11th of May 2009, and her interactions with T were all recorded in T's case file, which was in evidence at trial. Now, at the first meeting with T, T informed Ms. Turner that the issues she wanted to address were mental health, drug use, sexual abuse, and attachment. And T soon began to confide in Ms. Turner about the sexual abuse that she'd suffered as a child, and Ms. Turner noted early on that many of the conversations she had with T were sexualized. Now, around the time that T started receiving support from Ms. Turner, she also received services from Laura Christie, who was to provide drug intervention services for T. Ms. Turner visited T every few days. She took T to her midwife appointment, she took her grocery shopping, and together they arranged for the delivery of a cot for T's expected baby. So there was quite a close, intensive level of support with Ms. Turner. Ms. Christie, on the other hand, saw T less frequently. T's baby was born in July 2009, and the concerns around this time that were noted by Ms. Turner and Ms. Christie were T's mental state, her drug use, inability to care for her children, and a desire to buy sharp knives for self-harm. In August 2009, Ms. Turner noted that T was making frequent attempts at physical contact and T became angry when Ms. Turner asked for her to stop. With T's consent, Ms. Turner related T's difficulties with sexual boundaries to T's psychologist. Later in August, T began messaging Ms. Turner and expressing confused feelings about their working relationship. And shortly after this, Ms. T noted that she had concerns for her own safety and also for those of T's children. So following this, sort of towards the end of August 2009, T made written threats to Ms. Turner's safety. Now, there wasn't a lot of evidence in the decision as to what these threats were about, but there was evidence led that T had told Ms. Turner of fantasies where she killed Ms. Turner and performed sexual acts on her dead body, and T was apparently quite explicit in these communications. Ms. Turner told T that such threats were not okay, and at this time Ms. Turner ceased providing support in T's home. However, she did agree to provide limited support if T wanted outside of the home in a more office-based environment. In September 2009, T's children were removed from her care, but Ms. Christie continued to provide in-home care for T and to take T to various appointments. In October 2009, T sent text messages to Ms. Turner expressing a desire for an inappropriate relationship, and she also sent pornographic images. And in November 2009, T began making sexualized comments towards Ms. Christie. She continued her sexualized text messages to Ms. Turner. In December 2009, T then started to talk to Ms. Christie about wanting to stalk, rape and drug somebody. And she also said that she had followed Ms. Christie, or perhaps had her followed. Ms. Christie chose not to give much weight to these fantasies. Her program was designed around positive behaviours, and she didn't want to dwell and focus on these negatives, although she did apparently inform her superior of T's desires and fantasies. And the desire to stalk remained a theme throughout 2010, and T's drug use also continued. So she was using methamphetamine. It also seems that she was using cocaine and heroin. And the inappropriate sexual behaviour and advances also continued through 2009. In June 2010, Ms. Christie and Ms. Turner discussed T's case and agreed that T required some psychiatric treatment and prescription medication. Ms. Christie attempted to place T with a psychiatrist, but this was without much success due to T's continued drug use. And since T's children were removed in September 2009, Ms. Turner, and then when Ms. Turner ceased providing home visits, Ms. Christie supported T at meetings with the Department of Child Safety. And these meetings took place at the department offices or perhaps at the Children's Court and Family Court, depending on the requirements. In September 2009, Ms. Christie approached Ms. Beven to see if she could support T during her contact time, and also at these meetings with Child Safety to provide advocacy for T. Ms. Christie said that she wasn't equipped with the knowledge or expertise to really navigate the child support system, and it was at this point that Ms. Beven became involved in T's care. So the question now is, what did Ms. Beven know before she decided or agreed to commence supporting T? Well, she had observed Ms. Turner weeping after particular advances from T. She'd seen a letter from T to Ms. Turner which made explicit sexual advances towards Ms. Turner, and she'd also noticed T hiding behind a pole outside BYS premises after Ms. Turner ceased making home visits to T. It seems that T was self-harming at this time, and Ms. Beven called an ambulance and the police, and T was taken away. Ms. Beven also provided evidence that she had seen T on one occasion at a meeting at McDonald's slide her hand down the back of Ms. Christie's pants. So Ms. Christie actually didn't recall this incident, and there was no record of it in the notes. Ms. Bevan had been in attendance at weekly meetings where T's behaviour was described, and she had access to, although it seems she hadn't read T's case notes. There was also a meeting on the 14th of October 2010, which Ms. Bevan was present at, and a question was raised at this meeting whether T was really an appropriate client of BYS, given her intense problems and her history of interactions with BYS staff, in particular Ms. Turner. So by Ms. Bevan's own evidence, she had an awareness of the nature of the client she was taking on. It seems she was aware that there was some unsafe aspects of working with T, but she felt confident in supporting T with child safety, advocacy, and to work with T and her children. So it should be noted that the support that was going to be given by Ms. Bevan was not of the intense nature of support that was provided by Ms. Turner, but it was to provide an education program around parenting and to attend meetings in a public forum to provide advocacy in child safety. What Ms. Bevan didn't know when she agreed to support T was the existence of a handwritten document that T had provided to Ms. Christie, which provided quite a lot of detail in relation to T's sexual abuse anger and voices that she had about stalking and raping women, and how she always thought of people that she met in a very sexualised way. So Ms. Bevan commenced supporting T on the 25th of November 2010, and there's little in the decision about the interactions between Ms. Bevan and T. But on the 13th of April 2011, Ms. Bevan was at a family group meeting with T at a departmental office. T's mother was present, as was a lawyer from Legal Aid and 2 department representatives. During the meeting with T, T lifted her leg to caress Ms. Bevan's leg, and she sexually assaulted Ms. Bevan. Ms. Bevan told her to stop, and the meeting was adjourned. But Ms. Bevan decompensated. She took some time off work, but she never regained her health sufficiently to return to work. So that's the factual background. I appreciate that's quite lengthy, but it's obviously quite relevant to the findings. So Ms. Bevan brought an action against BYS for negligence. So there's just a little diagram there of an employer's duty. It was admitted that BYS had a duty of care to Ms. Bevan. That's uncontroversial. And the duty was to take reasonable care to avoid a foreseeable risk of injury to the plaintiff while she was engaged in carrying out her work for BYS. And it was noted in the decision that what is a reasonable standard of care for an employee's safety is not a low one. So whether there's been a breach of duty is determined by the question of reasonable foreseeability. That is a risk not far-fetched or fanciful? And if it's not far-fetched or fanciful, then it's foreseeable. So the question then is what a reasonable employer should do in response to such a risk. Having regard to considerations such as the magnitude of the risk and the degree of probability of its occurrence, along with the expense, difficulty and inconvenience of taking alleviating action and any other conflicting responsibilities which a defendant might have. There's also a statutory requirement from the Workers' Compensation and Rehabilitation Act for the employment to be the major significant contributing factor to the psychiatric injury. So at first instance, Justice Atkinson decided there was a plethora of evidence that should have alerted BYS to the risk that T would sexually assault one of the employees. And adding to that risk was her continued drug use. And whilst it wasn't inevitable that the assault would occur, the risk was clearly foreseeable. And, you know, both Ms. Christie and Ms. Turner had ceased working with T because they felt unsafe doing so. So there was a foreseeable risk of an assault occurring, and it was also clearly foreseeable that sexual assault would give rise to a psychiatric injury. And there was evidence on this from an expert psychiatrist. So given the potentially serious consequences of the foreseeable risk eventuating, Justice Atkinson found that BYS should have exited T from all services. She stated that whilst the work of BYS is important and socially valuable, it doesn't displace the duty of care to its employees. And whilst Ms. Bevan's role was of a less intense nature than, say, Ms. Turner's, what BYS failed to take into account was that while the assault didn't take place in T's home, the home visits gave T an opportunity to develop and express an unhealthy level of intimacy with Miss Bevan, as she had previously with Miss Turner and Miss Christie, which she then took advantage of to engage in the sexual assault. So this wasn't a case where the plaintiff suffered a psychiatric injury because of stress caused by stressful work, which she had agreed to do as part of her contract. This was a case where she suffered a psychiatric injury as a result of a sexual assault, which obviously she had not contracted to be engaged in, which happened during the course of her employment. It was unlikely that the plaintiff would have developed the psychiatric condition had the sexual assault not occurred. And despite her history, her own history of sexual abuse and her previous decompensation, it was found that this simply contributed to the seriousness of her ultimate decompensation following the sexual assault. So there are the damages. It was quite a significant injury, and it was unlikely that that Miss Bevan would be returning to work. So it's quite significant damages there of 1.5 million. So BYS appealed the decision, and on appeal it was alleged that the risk of psychiatric injury was insignificant, and the burden for taking precautions was not low, because the whole reason for BYS being in existence was to work with clients such as T. So to prevent them from doing so was quite a high burden. It also pleaded that Ms. Bevan had agreed to work with T despite having information available to assess the risk of injury for herself. So as to the significance of the risk, Justice McMurdo provided a dissenting judgment, and she delivered a decision that the risk, while foreseeable, didn't require the withdrawal of all services to T, and that the risk of a sexual assault occurring at a department office was so low as to be insignificant, and she would have allowed the appeal. She was of the opinion that there was a foreseeable risk of injury, but this foreseeable risk could have been dealt with by ceasing the home-based support to T, which obviously wouldn't have prevented Ms. Bevan's injury from occurring. The majority, however, formed a view that whilst most people would feel constrained in their behaviour by the presence of others, T was not such a person, and this was illustrated by her past behaviours. And as such, there was a significant risk that she would behave in an impulsive, sexualised manner towards Ms. Bevan, and a government office should not be considered a place of safety. As to the burden of taking precaution, by exiting T, the majority found that this wasn't a situation where T would have been left without recourse to other services to which she would possibly have been better suited. It was noted that despite 2 years of intensive support from BYS employees, T had made little in the way of progress, and the programs provided by BYS were perhaps of no benefit to T, and so exiting her from the service and perhaps referring her to a more appropriate service wasn't found to be too high a burden in response to the foreseeable risk. So as to Ms. Bevan's agreement to work with T, it was noted that the role Ms. Bevan agreed to take on was different to that of Ms. Turner and Ms. Christie. She was to deliver an education program and attend formal meetings. So it wasn't a part of her role to support T in relation to her mental health or her drug-induced problems. And importantly, it wasn't part of her role to anticipate whether she would be exposed to the risk of sexual assault. So this wasn't a case where the plaintiff suffered an injury doing precisely the work that she had contracted to do. And in this regard, the decision was distinguished from the case of Kohler. So in that case, the plaintiff sustained an injury while doing exactly the work that she was contracted to do, which in that case was travel between a number of stores in a defined period of time, and her efforts to complete this work led to her illness. And in that case, it was observed that an employee's acceptance of a position permits the employer to assume that in the absence of evident signs of warning of a possibility of psychiatric injury, the employer considers themselves able to do the job. Now, this was distinguishable from Ms. Bevan's case. There was evidence presented at trial from a psychiatrist confirming that Ms. Beven was particularly well suited to her role, and obviously it wasn't the work that she was contracted to do that caused her injury. It was a sexual assault that occurred during the course of that work. And in terms of Ms. Beven as a social worker being able to assess the risk of a client and act accordingly, it was emphasised that an employer should be the one to assess the risk, regardless of an employee's willingness to do the work. And this is especially so in a profession such as social work, where an employee will often sacrifice their own needs in favour of their client's interests. So it's really important in that case for an employer to take an objective view and to be the one to take the steps to say, no, you can't do that work. It's, you know, there's a risk of injury, and we're not going to allow you to do that. Excuse me. So, as you may have guessed, the appeal was dismissed. So that brings us to the implications of the case. And I think the key finding to remember and to take away from the case is that the duty of care, excuse me, the duty of care owed by an employer to its employees outweighs any social obligation that that service might have to provide service to an individual in circumstances where those individuals present a foreseeable risk to the employees. Now, what your obligations are will depend on your particular role. So we did a poll at the beginning to see. So we have principal solicitors, employed solicitors, and other. So, you know, depending on your role in the organisation that you work in, which appears to be mostly community legal services, will depend on what's required of you. There's also, of course, ethical considerations, any professional frameworks that you work within, any code of ethics, and any legal requirements. So considerations of the Privacy Act. For those of us who are legally qualified providing legal services, there's obviously the solicitor's rules regarding confidentiality and privacy, and any mandatory reporting requirements that you might have as for example, a health service provider. So What about employers? Employers, principal solicitors, managers. I think, the important thing to take away from this case is that it's really the employer, the senior members of staff who need to take the active steps to manage risk. So various different things required there. Identifying in the first place, I suppose, whether a client is an appropriate one for your service. Are you equipped to handle their specific needs? And then identifying any risks that they might have in terms of the nature of the service that you're providing, a client's specific personal circumstances and characteristics, and the environment that your assistance is being provided in, whether that's home visits, whether it's in a public space, or whether it's in an office environment. You need to then assess the magnitude of those risks and develop strategies to manage those risks before an incident such as this arises, whether that's in terms of behavioural contracts with your clients and providing strategies for team members to deal with aggressive behaviour and threats. Obviously, it's important not to have too many policies for workers to get across and understand, but to make sure that there's appropriate policies and structural steps to take when faced with difficult client situations. Obviously, staff training is an important one, providing ongoing guidance around risk, when incident reports should be made, maintaining boundaries, appropriate communications, those kinds of things. I think, there's also provide strategies for staff around managing their personal safety, whether it's, sitting by the door, keeping the door open, having two people present. And perhaps for those of us who don't have sort of any health background, key signs and symptoms of common mental health issues could be useful for lawyers to have. It's obviously important to make sure that everything is documented. Lawyers, we like everything to be documented so that we have written evidence to rely on. It's also important to document your decision-making process when it comes to perhaps needing to terminate services of a client. And last, but I think by no means least, is to take action. And I think that, again, that's something that this case highlights. It's really important. You can have all of the strategies and policies and training in place, but if senior managers aren't taking action when faced with unsafe situations, then that's going to be a downfall. Ensure that there's adequate resources to make available to workers if required, or security if required, and if you don't have those resources, then consider what you can do. Developing links with specialist agencies that might be able to assist with particularly difficult clients, and ensure that there's open communication and consultation, and I suppose foster a culture where employees don't feel that they have to put themselves in a position where they may be unsafe. Obviously, it's important not to become too risk averse, as was said in this case. The whole point of BYS being there was to provide services to complex and vulnerable people. So, if your first impulse is to exit all of those clients, you probably would not have a lot of work. But it's really just important to manage the risks as best as possible and take action when action is required. In terms of staff members or employees, as a legal services provider or a health services provider, depending on which area you're working in, we've all got privacy issues to deal with. There's obviously confidentiality obligations and privacy implications, but it's important to be aware of the exceptions to that. So the solicitor's rules provide exceptions to the duty of confidentiality. Obviously, the preferred one is consent. So it might be that you're able to obtain a client's consent should they be exhibiting behaviour that you feel needs to be elevated and disclosed to another person for the safety of your colleagues, other employees of the service. And there's obviously permission to disclose information if it's for avoiding probable commission of a serious criminal offence or for the prevention of imminent serious physical harm either to the client or to another person. So I suppose it's important to use common sense and sound judgment there in determining whether confidential information should be disclosed for this purpose. Specifically, seriousness of potential injury and the imminent and likeliness of harm occurring. But I think it's just important to remember that you do have that reasonable excuse to breach confidentiality if you feel that there is an imminent risk of harm and you feel that information needs to be provided, whether it's to a senior colleague or whether it's to the authorities, police or ambulance to prevent that harm. And obviously if there's any issues, certainly from someone providing legal services, there's the Law Society. Queensland Law Society has an ethics support advice line, and presumably the other states have something similar. And of course, having in mind to privacy and confidentiality, senior colleagues and other colleagues can also provide guidance in that regard. So that brings me to the end of my presentation. I'd be happy for any comments that anybody might have or any questions.
Thanks, Helen. That's fantastic. So I'll just give everyone a rundown of how to ask questions in case you're new to our webinars. So on the GoToWebinar control panel in the top right corner of your screen, you should see a questions or chat area. So you can type your question in there and I will read those questions out for Helen to respond to so everyone can hear. Alternatively, if you've got a microphone, you can press the button that looks like a hand and we'll see your hand go up and we can then unmute you if you'd like to ask your question verbally. So I'll just give you a little bit of time to pop your questions through to Helen. Okay. So Helen, perhaps you might be able to answer. It's not something that's directly come out of this case, but obviously our community legal centres engage quite a few volunteers to assist them in delivering services to their clients. So they may be volunteer students, they may be volunteer solicitors or barristers, and they could also be volunteer social workers or other professionals. So would these obligations extend to volunteers as well as staff?
They would, yeah, they would extend to volunteers, and the Workers' Compensation, Workers' Compensation Rehabilitation Act extends to volunteers as well. So you would need to be taking steps to protect a volunteer, just as you would protecting an employee.
Okay, great. Okay, so we've got another question that's just come through, Helen. Are you able to comment on to what extent workplaces need to go to understand the background vulnerability and risk to their employees or volunteers?
Yeah, look, as I said in the presentation, BYS wasn't aware of Ms. Bevan's pre-existing vulnerabilities, and nor was there an obligation for her to provide that information to them. I certainly don't think it's something that prospective employers could ask of prospective employees, that kind of background. And I think also at the time that Ms. Bevan was employed, she didn't have any illness. She didn't have any mental health problems at that time. And so even if there had been, say, a questionnaire to assess the health of a worker in relation to their suitability for employment, it's not something that I would have expected Ms. Bevan to disclose at that time, because as I said, she wasn't having any mental health problems at that time. So I think obviously there's discrimination legislation that we need to be cognizant of in asking those sorts of questions. She, at the time that she was employed, was fit and well to perform that role. So the background vulnerability really comes into play more in terms of assessing the damages. So it wasn't the case that Ms. Bevan sustained an injury that a person of, and they've sort of moved away from reasonable fortitude, but it wasn't that a person of reasonable fortitude wouldn't have suffered that injury. What the courts found was that it was reasonably foreseeable that a person, any person, would have suffered a psychiatric injury following a sexual assault. It just so happened that due to her background and pre-existing perhaps vulnerability, Ms. Bevan's injury was greater than perhaps that of someone who didn't have that background. So it's not relevant to sort of breach. Once it's been established that there's been that breach of duty that has caused an injury, the extent of the injury is then, fully compensable regardless of pre-existing vulnerability. So I think it would be difficult for workplaces to really assess the background and vulnerability of their employees. I think they need to take steps, to protect employees, and the foreseeability aspect of whether an injury is foreseeable is of a reasonable person. So if it was found that the injury wouldn't have been suffered by somebody who didn't have Ms. Bevan's background, so if the injury wasn't reasonably foreseeable, then there wouldn't have been a finding of breach. So I hope that answers your question. Really, it's difficult for a workplace to establish any of this vulnerability, but I don't think it would have made any difference in any event.
Thanks, Helen. I think that covered the question there. We haven't had any other questions through, so do you want to, pop your questions into the question box? This is a really good chance to ask an experienced lawyer some of these questions that you may have floating around in relation to your centres or workplaces. Or are there any other comments, Helen, that you would like to make in relation to this case?
I think I've covered everything. I'm just having a look through my notes to see if there's anything else that I can say.
So obviously for community legal centres, we see some of the most vulnerable and disadvantaged people in the community, so often they don't have anywhere else to turn. So it is quite possible that some of the clients that our members come across in their daily workplaces might have some of these attributes or pose a risk to employees or volunteers. I've just got a couple of...
and
Sorry, Helen.
sorry, I was just going to say, and obviously it is important to remember that each case turns on the individual facts, and in this particular case, it was noted that T had been in the service for about 2 years. She'd had quite intensive support during that time, and she hadn't really made any positive steps. So it was found that really it probably wasn't the right service for her in these circumstances, and there were other services, and BYS was actually aware of those other services that could have provided her with more appropriate treatment. Ms. Turner and Ms. Christie had talked about trying to get her help with a psychiatrist. Ms. Turner was a psychologist, but obviously she can't then prescribe medication, so it was felt that T required probably assistance that couldn't be provided by BYS in their service. And I think if you remember at the beginning, I spoke about BYS and what it described itself as, and that was a provider of support services to homeless and at-risk young parents and their children. So it was never really intended, I don't think, or the evidence didn't seem to be that it was really intended to be, an intensive drug rehabilitation program or an intensive mental health program. So I think in those circumstances, T could have benefited from being in a different service, and she wouldn't have been left high and dry, so to speak, had she been exited from the service. So that could be different. It could have turned out differently had T been really benefiting from the services that she was being provided with. If it was, a specialist service and she was doing really, really well, then maybe exiting her from all services wouldn't be a reasonable response to the risk of her causing harm.
Absolutely. A couple of questions have now come through. So, and we've got about 10 minutes, so I'm sure we'll be able to deal with those. So, Helen, do you think the implication of Justice McMurdo's dissent will be considered in future cases where the risk from a client is perhaps unexpected or very unexpected?
Yeah, and again, that goes back to the foreseeability aspect. You only need to protect against foreseeable risks, and Justice McMurdo didn't consider that the risk of sexual assault in that public arena with other people present was a foreseeable risk. She thought the risk was so low as to be insignificant. The majority, on the other hand, felt that given T's previous behaviours, she was very sexually forward with pretty much everyone that she met. They felt that she wasn't sort of constrained by boundaries of what people perhaps ordinarily would be, and so there was a risk of her sexually assaulting someone in a public venue. So yeah, I think if the risk is very unexpected, then I suppose you could say that it's not a foreseeable risk, and therefore an employer wouldn't need to take steps to alleviate the risk.
Okay, yes, that makes sense. So I've got another question here. How might community organisations keep up to date with their employer responsibilities? So if you've got any good links and places people can go to make sure they are managing their risk and, keeping themselves informed, that would be helpful. Thanks, Helen.
Gosh, I think
You're on the spot.
Put me on the spot there, but I think in terms of keeping up to date with responsibilities, the responsibilities been, hasn't really changed for quite some time. The responsibility is, and now let me just find where I've written this in my notes, because so that it makes sense. The duty is to take reasonable care to avoid foreseeable risk of injury while an employee is engaged in their employment. So that's the responsibility, and that's been the responsibility for some time. I think in terms of keeping up to date is, I suppose, to attend CLEs such as this one, and keep an eye out for any other sort of CLE type seminars that might highlight developments in cases and provide information in relation to any changes.
Great, that's some good suggestions, I think. Another question here. So what if the duty of the employer would have required terminating the services to a client, but that was not an option to the employer who must provide those services? So, for example, if the employer is Unity Water and it must send a person to service a risky person's water main. Not sure if that makes sense, but hopefully I explained that okay.
Yeah, so if the employer had an obligation to provide the service, then I suppose you would need to be looking at other reasonable steps that can be taken to reduce risk of injury. So do you send 2 people out to that water address, or do you send 2 people to, I mean, obviously it wouldn't have provided any assistance in this case, because the incident occurred with a number of other people in the room. But you consider other reasonable steps that you can take. Do you have a security guard on your premises? Depending on your clientele, do you require that extra service, or can it be alleviated by obviously having consideration to privacy and confidentiality? Can you leave the door open? Can you be in an open office environment rather than being in a private room? Do you have 2 people on a home visit, or do you simply withdraw home visits and require that the client comes to your offices, or to McDonald's, where it seems that some of these meetings had taken place in the past? So there's lots of other things, I suppose, steps that you can take without withdrawing services. I think it was just in this particular case, the only I suppose reasonable response was to withdraw services.
And on that note, I have a final comment from one of our viewers. So the question to withdraw services is a difficult one. Services always have to weigh up their duty of care to employees with the availability of service to the disadvantaged. The withdrawal of services has a big impact on clients, and we receive public monies to deliver them. It can be a vexed quandary, which I think you'll agree.
It can, and I think that was the slide that I put up with the circles, with the your role, your ethical and your legal responsibilities. They all sort of overlap, and you've kind of got to consider the big picture. But I think that the key message from this case is that your employees take precedence, and the safety of your employees take precedence. I think there's often alternative services, and I have heard of in the past instances where services might have links with each other, and they make sure that the client is never exited from all services at the same time. So they might be suspended from one service, but they're not suspended from the other service, and then when they do something and get suspended from that service, they're allowed to come back. So you kind of get that break, I suppose, and they still have access to services, but ultimately it's obviously key to ensure that your employees aren't left at risk of serious assault, and that is on the employer to to take those steps, regardless of whether employees are keen and willing to provide services. That duty is there for the employer.
Great. So I think we'll draw today's webinar to a close now. Thank you very much, Helen, on behalf of everyone who attended today. That was really informative, and certainly we can take some very important lessons from that case for the community sector. So everyone, if you wouldn't mind providing feedback on today's webinar, the webinar recording, PowerPoint, and link to the feedback SurveyMonkey quiz will be sent out to you this afternoon. Thank you again, Helen, for presenting today and sharing your expertise and providing a really valuable summary of those cases to our people.
Thank you. Thanks, Carly.
Cheers. Thank you.